do or die. Nobody should intimidate you in this house. Let's smile, feel at home. I know, I have seen how Solo is forcing to be annoyed. Hilderman is forcing to be annoyed, and yet when he looks at me, he smiles. Yes, can you move?
Right Honorable Speaker, in a nutshell, the object of the bill is to give effect to Articles 130 and 134 of the Constitution of the Republic of Uganda by prescribing additional number of justices of the Supreme Court and justices of the Court of Appeal. The bill further empowers Parliament to increase both the number of justices of the Supreme Court and justices of the Court of Appeal to such higher numbers as Parliament may by resolution prescribe. The judiciary staff establishment or structure was approved by Cabinet to facilitate the increase of the number of justices of the Supreme Court and justices of the Court of Appeal. So in a nutshell, Right Honorable Speaker and honorable colleagues, just like you indicated, this is the amendment we intend to introduce to the Judicature Act by amending it through this bill. I beg to submit and move.
Thank you. Thank you. Yes, a procedure, Richard.
Thank you, Right Honorable Speaker. Right Honorable, I thought you asked the minister to talk to the motion, and in my understanding, he was supposed to justify why we need this amendment. But the minister is telling us the object of the bill. The two are different in my view.
Okay, can you give the other view you think is correct?
Yes, my view is that we have now the current status, the status quo. The minister is supposed to tell us, why do we need to change that?
It will come in the report, Richard. I thought you have been here longer.
I've been here.
Yeah. Yes, Honorable.
Madam Speaker, the rules and practice of this House require that a minister representing another ministry, first they write to you and there is a letter. And this we have done before. So the procedural issue I am raising is whether the Honorable Bua, who is the Chief Whip of Government, has been duly assigned to deal with this matter, and the letter is with you, which, Madam Speaker, you can share with the Parliament.
Honorable Semojo, I have never shared any letter written to me with the Parliament. It's a personal letter written to Anita Moore, the Speaker. But it doesn't matter if somebody wants to be my secretary. You can come so that you have access to it. But as far as I know, I got a letter from Honorable Mao. And the problem is always in my office. I wish you had asked me. I would have showed you. I've just been with him. Now, Honorable Rakojo, can you now present the report?
Right Honorable Speaker, I would like to thank you for this opportunity. This is a report of the Sector Committee on Legal and Parliamentary Affairs on the Judicature Amendment Bill 2023. I have with me a copy of the report and copies of minutes, which I beg to lay on table.
That's the Ruridi area where we started from our journey.
Madam Speaker and members of the House, on Wednesday, 22nd November 2023, a bill entitled the Adjudication Amendment Bill 223 was in accordance with Rule 128 of the Rules of Procedure of Parliament, read for a first time and referred to the Committee on Legal and Parliamentary Affairs for scrutiny. The minister has already read the object of the bill. Really, it is to give effect to Articles 130 and 134 of the Constitution by prescribing additional numbers of judges to the Supreme Court and justices of the Court of Appeal. The bill further empowers Parliament to increase both the number of justices of the Supreme Court and justices of the Court of Appeal to such higher numbers as Parliament may by resolution prescribe. The committee adopted the qualitative method in interacting with stakeholders, whereby the committee only invited persons and entities whose mandate is connected to the exercise of judicial power in Uganda. We met the following entities: Ministry of Justice and Constitutional Affairs, the Judiciary, the Law Development Center, Uganda Law Reform Commission, and we also received written submissions from Judicial Service Commission and Uganda Law Society. Justices of Court of Appeal and Supreme Court. Article 129 of the Constitution of the Republic of Uganda provides that judicial power in Uganda is exercised by the courts of judicature that consist of the Supreme Court of Uganda, the Court of Appeal, the High Court, and such subordinate courts as Parliament may by law establish, including Cadi's courts for marriage, divorce, inheritance of property, and guardianship as may be prescribed by Parliament. Article 129(2) designates the Supreme Court, Court of Appeal, and the High Court of Uganda to be superior courts of record. Article 1(3) of the Constitution provides for the Supreme Court of Uganda and its composition and requires that the Supreme Court is composed of the Chief Justice and such other numbers of justices of the Supreme Court, not less than 6, as Parliament may by law prescribed. And it is reproduced saying the Supreme Court shall consist of A, the Chief Justice, B, such number of justices of the Supreme Court not being less than 6, as Parliament may by law prescribe. Article 134 of the Constitution provides for the Court of Appeal of Uganda and its composition and requires that the Court of Appeal is composed of the Deputy Chief Justice and such other numbers of justices of the Court of Appeal, not less than 7, as Parliament may by law prescribe. And it reads as follows: the Court of Appeal of Uganda shall consist of the Deputy Chief Justice and such number of justices of appeal, not being less than 7, as Parliament may by law prescribe. So Articles 130 and 134 prescribe the minimum number of justices of Supreme Court and Court of Appeal being 6 and 7, respectively, and delegates to Parliament the duty to prescribe the total number of justices of the Court of Appeal and Supreme Court by law. As commanded by Articles 130 and 134 of the Constitution, Parliament enacted the Judicature Act, Cap 13, to generally provide for matters relating to the judiciary, especially the composition of the Court of Appeal and Supreme Court. Section 3 of the Judicature Act gives effect to Article 130 of the Constitution and prescribes the composition of the Supreme Court to be 10 justices and the Chief Justice, making a total of 11. Section 3 is reproduced below, saying the Supreme Court shall consist of the Chief Justice and 10 justices of the Supreme Court. On the other hand, Section 9 of the Judicature Act gives effect to Article 134 of the Constitution and prescribes the composition of the Court of Appeal to consist of the Deputy Chief Justice and 14 justices of appeal, making a total of 15. It's reproduced as the Court of Appeal of Uganda shall consist of the Deputy Chief Justice and 14 justices of the Court of Appeal. Now, when we go to your analysis of the provisions of the bill, this part examines the amendments proposed by the bill and its legality and effect and effectiveness to deal with the mischief it intends to cure. The committee makes recommendations on each of the proposals in the bill. 5.1, Clause 1, increase in the number of justices of the Supreme Court. Clause 1 of the bill proposes to amend Section 3 of the Judicature Act by substituting it for the following: that the Supreme Court shall consist of the Chief Justice and be 20 other justices of the Supreme Court, or such higher number of justices of the Supreme Court as Parliament may by resolution prescribe. Section 3 of the Judicature Act currently provides as follows: the Supreme Court shall consist of the Chief Justice and 10 justices of the Supreme Court. So it is Chief Justice and 20, that's what's being proposed. What is currently there is Chief Justice and 10. The amendment Section 3 of the Judicature Act has the effect of increasing the number of justices of the Supreme Court from 11, including the Chief Justice, to 21 justices. and B, changing the mode of prescribing the number of justices of the Supreme Court from prescribing the number by legislation, as is currently the case, to prescribing the number by resolution of Parliament. The Ministry of Justice and Constitutional Affairs and the Judiciary justified the amendment on the need to effectively and efficiently deliver justice to the people of Uganda and to deal with case backlog in the Supreme Court. The committee was informed by the Ministry of Justice and the Judiciary that the intention of increasing the number of justices from 10 to 21 is to create 3 panels in the Supreme Court instead of the current 1 panel. These panels will be able to sit at the same time to expeditiously handle cases filed in the Supreme Court, thereby reducing on the huge case backlog that exists in the Supreme Court. The Ministry of Justice and Constitutional Affairs and the Judiciary explained that currently there's a huge case backlog in courts of record, and further explained that case backlog in the Supreme Court, that's cases that have been in court for 2 and more years from the time of their registration, stands at 353 cases, and pending cases that have been in court for less than 2 years from the date of their registration, stands at 792 cases as at 31st October 2023. There's a table that shows the cases pending before the Supreme Court for the last financial years, and that is it. The Ministry of Justice and Constitutional Affairs and the Judiciary averred that the backlog at the Supreme Court requires more manpower to deliver justice to the people of Uganda effectively. Hence, the proposed amendment to the Judicature Act, Cap 13, in Section 3, to increase the number of justices of the Supreme Court as envisaged by Article 130 of the Constitution, hence the proposed amendment. The Minister of Justice, while appearing before the committee, considered that the proposed number in the bill was high. He proposed to the committee that the number can be reduced to 4 justices in addition to the current number of 11. The committee has examined the bill and presentations made on the matter and is of the considered opinion that the proposal to increase the number of justices of the Supreme Court from the current 11 to 21 be rejected. In arriving at this decision, the committee is of the opinion that instead of appointing additional justices of the Supreme Court, case backlog experienced at the Supreme Court can be dealt with through the following measures. A, appointment of justices at the Supreme Court in acting capacity under Article 142.2 of the Constitution. Article 142.1 of the Constitution empowers the President, acting on the advice of the Judicial Service Commission, to appoint judicial officers in courts of record. On the other hand, Article 142.2 also empowers the President, acting on the advice of the Judicial Service Commission, to appoint a person qualified for appointment as a Justice of the Supreme Court or Justice of the Court of Appeal or a Judge of the High Court, to act as such a Justice or Judge, even though that person has attained the age prescribed for retirement in respect of that office. Article 142.2 is intended to enable the President fill positions in the Supreme Court, Court of Appeal, and the High Court in situations where A, the office of a Justice of the Supreme Court or a Justice of Appeal or a Judge of the High Court is vacant. B, a Justice of the Supreme Court or a Justice of Appeal or a Judge of the High Court is for any reason unable to perform the functions of his or her office. C, the Chief Justice advises the Judicial Service Commission that the state of business in the Supreme Court, Court of Appeal, or High Court so requires. The committee is of the opinion that Article 142.2c can be invoked by the Chief Justice to appoint justices on the Supreme Court on temporary basis in order to deal with case backlog in the Supreme Court. The committee observes that it's cheaper and more efficient to appoint acting justices at the Supreme Court to deal with the issue of case backlog, since the acting justices are not entitled to retirement benefits. And once case backlog is cleared, then the appointment of such persons is revoked under Article 142.3 of the Constitution. This will therefore remove the need to appoint a high number of justices at the Supreme Court and alleviate the increased costs associated with increasing the number of justices as proposed in the bill. The committee is fortified in this opinion by the recommendation from the Judicial Service Commission, which also recommended that instead of increasing the number of justices of the Supreme Court as proposed in the bill, government should consider appointing justices on temporary basis as provided in Article 142.2c of the Constitution. The Judicial Service Commission informed the committee that the President had in the past appointed judicial officers on temporary basis to deal with a specific need in the judiciary. This avenue has not been explored by government before proposing to increase the number of justices of the Supreme Court. The committee has also examined the issue of case backlog and is of the considered opinion that the solution for case backlog at the Supreme Court is not increasing the number of justices, but creating efficiency in case management and reviewing the jurisdiction of the Supreme Court so that the Supreme Court only handles matters of law, thereby reducing the matters that can be filed by the Supreme Court. B, review of the jurisdiction of the Supreme Court. The committee is aware that the jurisdiction of the Supreme Court is prescribed in Article 132 of the Constitution and Sections 4 and 5 of the Judicature Act. Under those provisions of law, the jurisdiction of the Supreme Court is as follows. A, the Supreme Court is the final court of appeal and handles appeals from decisions of the Court of Appeal while exercising its mandate, its appellate jurisdiction from decisions of the High Court or its original jurisdiction as a constitutional court. B, the Supreme Court has original jurisdiction in presidential petitions as prescribed in Article 1042. C, the Supreme Court also has criminal jurisdiction in the case of an offense punishable by a sentence of death on a matter of law or mixed law and fact, where 1, the Court of Appeal has confirmed a conviction and sentence of death passed by the High Court. 2, the High Court has acquitted an accused person, but the Court of Appeal has reversed that judgment and ordered the conviction of the accused. 3, where the High Court has convicted an accused person, but the Court of Appeal has reversed the conviction and ordered the acquittal of the accused. 4, where the Court of Appeal has confirmed the acquittal of an accused by the High Court. The committee is concerned that currently all manner of matters can be appealed to the Supreme Court, including matters of fact, which should ordinarily be handled by lower courts. This creates case backlog in the Supreme Court, since the number of cases that are filed exceed the capacity of the Supreme Court to dispense of them. The committee opines that the Supreme Court should only handle matters of law so that it can guide and set standards for lower courts on the application of such matters of law. The opinion of the committee is informed by the practice in most Commonwealth jurisdictions, where the Superior Court in most countries only handles serious matters of law, and in some cases, only matters that the Supreme Court finds to be of great public importance. The table below shows the different countries and the jurisdiction of their Superior Court. In Kenya, under Article 163 of the Constitution, the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the President. Appeals can only be a matter of right. Where the case involves interpretation or application of the Constitution, or a matter certified by the Supreme Court or the Court of Appeal as one that involves a matter of general public importance. In South Africa, the Constitutional Court of South Africa is the highest court in South Africa, and it deals with matters of general public importance in addition to constitutional matters. In Nigeria, according to Section 230 and to 236 of the 1999 Constitution of Nigeria, the Supreme Court of Nigeria has original jurisdiction in any dispute between the Federation and a state or between states if and insofar as that dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. The Supreme Court has no jurisdiction in criminal matters. In Ghana, Article 129 of the Constitution of Ghana 1992, the Supreme Court has jurisdiction in all matters relating to the enforcement or interpretation of the Constitution, and all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under this Constitution. It also has appellate jurisdiction as follows. An appeal lies to the Supreme Court as of rights, in which a civil or criminal cause or matter in respect of which an appeal has been brought to the Court of Appeal from a judgment of the High Court or a regional tribunal in the exercise of its original jurisdiction, or with the leave of the Court of Appeal in any other cause or matter where the case was commenced in a court lower than the High Court or a regional court or a regional tribunal, and where the Court of Appeal is satisfied that the case involves a substantial question of law or is of public interest. Well, there's also India, the US, United States. I'll leave those for members to read. From the above table, it's evident that the jurisdiction of the Supreme Court is limited to the most serious cases, those involving constitutional interpretation, matters of law, and matters of great public importance. It's the opinion of the committee that instead of expanding the number of justices in the Supreme Court, the jurisdiction of the Supreme Court be reviewed in order to limit the cases that are filed at the Supreme Court. C, establish a court case sieving system at the Supreme Court. The committee is aware that due to the very jurisdiction of the Supreme Court, certain matters that end up at the Supreme Court should not ordinarily be filed with the Supreme Court. These matters include matters of law that have been settled by the Supreme Court, thereby creating case backlog. This is because there is currently no system to sieve out matters that can be handled by the Supreme Court in order to ensure that the matters are filed in the Supreme Court. And the matters that are filed in the Supreme Court are matters that deserving the attention of the Supreme Court. The committee is of the opinion that there is need to introduce a case sieving system at the Supreme Court to ensure that only matters of law and serious matters are referred to the Supreme Court, thereby weeding out matters that are not deserving to be heard by the Supreme Court. The committee is aware that a case sieving system is employed in a number of countries, including the USA and Denmark, and has been very instrumental in reducing frivolous and unnecessary cases that are filed in courts. The court sieving system ensures that only cases dealing with new and novel matters are entertained by the Supreme Court, so that the Supreme Court dedicates its time to serious matters of law. C, reviewing the pecuniary jurisdiction of magistrates' courts. The committee notes that currently courts of record in Uganda are experiencing high instances of case backlog. The high cases of case backlog in the courts of record is attributed mainly on the low pecuniary jurisdiction of magistrates' courts, which results in the filing of cases before courts of record, thereby creating backlog in the courts of record. The committee is aware that Section 207 of the Magistrate Courts Act grants magistrates' courts pecuniary jurisdiction over matters of a value not exceeding 50 million shillings in the case of a chief magistrate and 20 million for magistrate grade 1. The stakeholders with whom the committee interacted recommended that there is urgent need to review and expand the pecuniary jurisdiction of the magistrates' courts to ensure that cases which are currently filed at the High Court can be disposed of at the magisterial level, thereby reducing the case backlog in the courts of record. The committee is concerned that even if the number of justices of the Supreme Court is increased, those measures will not be successful in dealing with the issue of case backlog in the Supreme Court, since the cases arising from the lower court will not be abated. It's the opinion of the committee that expanding the jurisdiction of magistrates' courts will therefore ease the workload of the courts of record and will release the courts to deal with the most deserving of cases instead of wasting time on matters which can easily be handled by the lower courts. D, appointment of court administrators. The committee is aware that judicial officers in Uganda exercise both administrative and judicial functions, which affect their productivity and efficient exercise of their judicial functions. For instance, the Chief Justice is the head of the judiciary, sits on the Judiciary Committee, while other justices of the Supreme Court serve as inspectors of court, represent the judiciary on administrative bodies, are appointed by the President to serve on other institutions of government and courts in other jurisdictions and international bodies, and also perform many functions in addition to their judicial work, including human resource management, fiscal administration, case flow management, technology management, information management, jury management, space management, intergovernmental liaison, community relations, research and advisory services, and secretariat services. The appointment, secondment, and assignment of judicial officers to other international bodies and jurisdictions, as well as the grant of administrative functions to justices of the Supreme Court and Court of Appeal, takes away from those courts valuable members and denies the court the efficient and timely exercise of its functions, thereby affecting its productivity and creating case backlog. The committee is of the considered opinion that judicial officers, especially in the courts of record, should not be allowed administrative functions or allowed to take up paid positions in other jurisdictions in order to ensure that they dedicate their time to dealing with judicial work. E, introduction of
Samuel from Verona High School, Mutuge Sibula. We came this side of Lugogo for an educational trip for our study. So, according to me, independence means a day of like liberation, a day of freedom. Because if we go into history, in the early 1960s, Uganda was ruled by the country by the foreigners, meaning they had taken control of our country. So now, like, independence has given us at least freedom. We have a leader of our own, a leader of our blood who is able to understand us at least. So now, for me, according to me, independence means a day of freedom, a day of loving. That means a day that we are released from the rest. That's what it means. What shows us that here we are really independent is at least that we are joint as many. As we look here, there are different schools. We have came for our studies, some are here for fun, some are here to shop. That shows that we are at least independent. Because if I remember, we never had a common language, not least 50%, or let me say most of us can speak English, making us at least united, making us one. So if this British never left us, or what shows that we are united here is that I'm able to speak to you with English. Now you see, maybe you're Muganda, I'm a northerner. The language you speak is the language I speak. That shows that at least this is independence. We are able to be together. In the early 90s, we couldn't even, you could not communicate with somebody from the north. You, like a Muganda, could only communicate with a Muganda, right? So now, like, to me, unity or independence is that.
Celebrating MTI independence.
Is 48 million, GDP 169 billion USD. Number of Supreme Court judges 11. The ratio is 1 to 4,300,000. And you continue looking at the others. The committee observes that on average, the most Commonwealth countries have an average of 10 justices of the Supreme Court. The table also indicates that on average, the ratio of population to the justices is 1 to 5 million people. Currently, the ratio of Supreme Court justices to the population stands at 1 to 4,300,000 people, well within the global average. The committee therefore finds that the number of justices should be left at 11, since that number is an international best practice. See, the committee is also concerned that the justification given by the Ministry of Justice and the Judiciary for expanding the number of justices, being the need to have 3 panels at the Supreme Court, will pose practical and constitutional challenges and may hinder the development of jurisprudence in Uganda. The committee notes that the Constitution in Article 132(1) directs the Supreme Court to be the final court of appeal and is indeed the superior court in Uganda in all matters. The committee is aware that Article 132(4) of the Constitution directs that decisions of the Supreme Court have a binding effect on all courts in Uganda, save that the Supreme Court can depart from its earlier decisions on a matter. The committee is concerned that the proposal to have more than 1 panel at the Supreme Court will result in decisions that may conflict on the same matter, since the composition of each panel will be different. This will affect the court users, since those conflicting decisions cannot be corrected by any other court owing to the fact that the Supreme Court is the highest court in Uganda, thereby affecting the development of jurisprudence. The committee is also concerned that it is impractical to have more than 1 panel at the Supreme Court, since Article 131(3) of the Constitution directs that the Chief Justice is to preside over the sittings of the Supreme Court, except in his or her absence, that the sitting is presided over by the most senior judge. The committee is of the considered opinion that the proposal to have 3 panels at the Supreme Court needs to be reviewed due to its practical and constitutional ramifications. The Constitution is also aware, the committee is also aware that in 2015, the then Chief Justice, Honorable Justice Bart M. Katurebe, instituted a committee to, among others, identify the extent of case backlog in the judiciary, identify and document the causes of the backlog, review current efforts to reduce the case backlog, and make recommendations to address the existing backlog and stop the growth of a new backlog. The committee was composed of Honorable Justice Richard Butera, Honorable Justice Efe Gondantende, Honorable Justice Dr. E. Chitimbo Chisache, Honorable Justice Geoffrey Chiriabwire, Honorable Justice Mike Chibita, Honorable Justice Stephen Musota, Honorable Justice Dr. Henry Peter Adonyo, His Worship Paul Gadenya, Mr. Kagole Expedito Chivumbi, Mr. Francis Gimara, Mr. Sam Rogers Wairagala, and Mr. Andrew Kauka. The committee made the following recommendations as far as case backlog is concerned. 1, maximize time spent in court. Stakeholders recommended that judges should spend their time more in the courtrooms, stroke chambers, handling cases. As such, any events which take judges out of the court should happen in a specific season to avoid disrupting the ordinary work of court. 2, improve performance of judicial officers and officers of court. It was recommended that attendance by judicial officers and officers of court must be strictly monitored and work ethic improved. The judiciary should put in place a system of rewards and sanctions, e.g., judicial officers who have not cleared their backlog should not be promoted. A reward might be in the form of a plaque recognizing the achievement made to the institution or different individuals involved. 3, staffing and placement. More judges be appointed and judges should be allocated with more reference to their area of expertise. Judges should not be transferred at short notice to avoid leaving part-hard cases. 4, jurisdiction. Expand the jurisdiction of the magistrates' courts so that they can handle more cases. The committee was not updated on how far the above cited recommendations have been implemented by the judiciary in order to assess their effectiveness and form a basis for increasing the number of justices of the Supreme Court. During the consultations, the committee also undertook a comparative study from other jurisdictions on the issue of case backlog with the intention of getting best practices to inform the committee recommendations. Many other jurisdictions have implemented measures that have reduced case backlog and increased efficiency. For example, in Kenya, a court census was carried out in 2013, and it resulted in the development of a case backlog reduction program, including 1, setting targets for magistrates, 2, the implementation of a judiciary performance management system so that the efficiency and workload of each
Is a
judge.
motion?
Pardon?
Is a motion?
Thank you, Right Honorable Speaker. I want to duly appreciate the chairperson for a very elaborate report, which is very, very clear. And as a legal mind, I cannot forget my first year introducing law, jurisprudence. Right Honorable Speaker, given the fact that this is a very simple amendment, I would like to move the motion under Rule 59, that the chairperson goes to the next level. We go to committee stage and deal with it, and then deal with other urgent matters. The bill is very clear and it's not controversial. Right Honorable Speaker, I beg to move.
Is that
Under
seconded?
59A, right Honorable Speaker.
Is it seconded? Seconded by Honorable Senyonyi. Even the one-man leader of Jema, Nakawa, the landlord Rubaga, by Malende, the landlady, by the LOP, by the whole opposition. All opposition. Honorable members, you've had the motion that has been moved. And honorable members, whereas Rule 204 4B indeed provides that once a report is submitted, it is given 3 days. This matter is about justice. Justice delayed is justice denied. So I want to invoke Rule 7 and the precedents that have already been set on us going ahead with this. Honorable members, since a motion has passed, I now put a question that the Judicature Amendment Bill 2023 be read for the second time. Those in favor say the contrary nay. The ayes have it.
The Judicature Amendment Bill 2023, Bills Committee stage.
Some roads are being maintained, so it will cause some bit of traffic jam. Yeah, I'm yet to cross the road. Abike is a suspect, the man. So now these are the UTL Service Center, Uganda Telecom Service Center, Service Center.
Clause 1.
We have the Mengo Chief
Honorable members, proceed at committee stage.
Mengo Chief Magistrate.
Let me hear from the Shadow Attorney General first. We're in serious matters now.
Totems here, those are the
Madam Chair, I have not seen anything requiring a procedure point.
Thank you, thank you.
Clause 1.
Clause 1, Chair. Chair.
Clause 1, amendment of the Judicature Act, cap 13. Delete clause 1. Justification, increasing the number of justices of the Supreme Court from 11 to 21 will not solve case backlog in the Supreme Court, since case backlog is caused not by lack of justices of the Supreme Court, but by other matters including inefficiency, poor case management, and the jurisdiction of the Supreme Court, which allows every matter to be referred to the Supreme Court. Increasing the justices of the Supreme Court will result in a bloated bench, deter easy and efficient decision-making, and will increase the burden of the taxpayer. Reviewing the jurisdiction of the Supreme Court, High Court, and Magistrates' Courts will result in a reduction in case backlog in the entire judiciary and reap more benefits than increasing the number of justices of the Supreme Court.
Honorable Minister. Honorable Minister. Honorable Minister.
Madam Chairperson, on Monday, we had a very...
Honorable Minister, is that okay with you or not?
The government disagrees with the recommendation of the committee.
What does government want?
Madam Chairperson, I thought we had reached a middle ground of 15 justices of the Supreme Court. We reduced the number from what we had requested, and we made some undertakings, namely that we are committed to access to justice 360 degrees. So the committee should have come to this house and also reported our undertakings and also the efforts that we reported to the committee, namely that we have enhanced the numbers at DPP, we have enhanced the numbers in the state attorneys, in the Attorney General's chambers by hiring more state attorneys. We have also introduced alternative dispute resolution, including plea bargaining to clear backlog in criminal cases. We are introducing mediation, arbitration, and conciliation. We have also agreed to draw clear boundaries for the work of the Supreme Court so that the Supreme Court is not bogged down adjudicating factual disputes, but to restrict itself to matters of law, which is what we know the Supreme Court is supposed to do. These are undertakings we made. We even went into a closed session with the committee. Madam Chairperson, I feel stabbed in the back by the committee because I thought we had reached an undertaking, and we are now appealing to the whole house to overrule the committee.
Honorable, the committee has not stabbed you at all. What the committee is saying, they propose that the Chief Justice will be given powers under Article 142, where we can be getting justices on acting capacities. And that is cheaper because it is easier for you to look after the justices on an acting capacity than the ones on permanent who are not working, who are on holiday. Yes.
I just wanted to show the minister that we actually were open to the house. On page 6, we said the Minister of Justice, while appearing before the committee, considered that the proposed number in the bill was high. He proposed to the committee that the number be reduced to 4, in addition to the current number of 11. But first, the next goes on to say the committee has examined the bill and presentations made on the matter and is of the considered opinion that the proposal increase the number of justices of the Supreme Court from the current 11 to 21 be rejected. So, Honorable Minister, we mentioned what you had said, but we didn't agree with you. Thank you.
Thank you. Thank you.
I just wanted to inform the minister, we did pass the Judicature Amendment Act in 2008, increased the number of justices of the Supreme Court to 11. But since then up to now, they have never appointed the 11. There are only 9 that have been appointed. So appoint up to 11.
Honorable Katuntu.
Thank you very much, Madam Chairperson. I think the minister is also stabbing us in the back. For us who sat with him and had a very candid talk, including issues we can't bring to this table. This morning, right, colleagues, we had a meeting with the Chief Justice and the Deputy Chief Justice. A very useful meeting, candid meeting, and we are honest to each other. It's not about you against Parliament or against the committee. This is about the country. It's about the judiciary. And all the issues we raised, the Honourable Minister, you agreed with them. You remember? We don't have to bring another conversation here, which we shouldn't be doing at this time.
Honourable Minister, can you
Madam Chairperson, we agreed on the access to justice 360 degrees, which goes beyond the bill. I am dealing with a practical matter. As you know,
Honorable members, we are not going to waste a lot of time on this. For me, it is a very simple thing. It's just a matter of putting a question. You get it, eh? Let's put a question and we see. Honorable members, I put a question that clause 1 be deleted as proposed by the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 2.
Clause 2.
For clause 2, they substituted the following. 2, substitution of section 9 of the Principal Act. The Principal Act is amended by substituting for section 9 the following. 9, the Court of Appeal shall consist of the Deputy Chief Justice and 29 justices of the Court of Appeal. The justification is that in light of the need to create a panel of 5 justices in each of the regions of Uganda, which currently do not have permanent courts of appeal, stroke constitutional courts, to increase the number of justices of Court of Appeal, stroke constitutional court from 15, including the Deputy Chief Justice, to 30 justices, including the Deputy Chief Justice. Currently, the law provides for 14 plus the Deputy Chief Justice, making them 15. Then we considered the other regions that traditionally don't have courts of appeal, Northern, Western, and Eastern. And we said, let's have 5 judges in each. Those come to 15. When you add the current 15 here, under the Constitution, those come to 30. That's how we got to that.
29. See, 29 plus 1, 30. Okay. Honorable Minister.
Madam Chairperson, justice is done in the name of the people and for the people. We are dealing with the practical problems, not matters of theories. We are proposing to have up to 9 circuits, and that is why we put the number at 56. And I thought the committee had agreed. So government disagrees with the position of the committee.
So it also has Best Buy supermarket along this road.
We are starting. Madam Chairperson, we have had some rapid consultations on the front bench, and I know that the Parliament is still here, and should there be need, we shall still be back. But I would still beg this House to add 5 more to the proposed 30. I think a spirit of give and take is healthy, because I am the one dealing with the people who are waiting for their appeal cases to be heard. And the practical matter I'm dealing with is the health of many of the Court of Appeal judges and the backlog which ties them down to carry out more research and to write judgments, which means the panels cannot be constituted at the same time. I ask that members add 5 to the 30 proposed by the committee. I beg to move.
Honorable members, let's have a win-win situation. You know, at the end of the day, it is all of us that end up in a court during election petition. They will not be hearing to our appeals. He is requesting for additional 5.
Right Honourable Speaker, maybe our chairperson may have a second thought about that request.
Madam Chair, I concede.
But will you appoint them? The question is, will you appoint, because the 11, you've not appointed all of them. First assure us that they are going to be appointed.
The current law provides for 15 in the Court of Appeal, but only 12 have been appointed since 2008. So will you appoint even the 35 when you failed to appoint the 15?
Madam Chairperson, first I would like to thank most sincerely the chairperson of the committee for this important concession. I also want to thank you, Madam Chairperson, for filling the vacancy which was in the Judicial Service Commission. Now that the Judicial Service Commission is fully functional, we promise that these appointments shall be made, and there are enough Ugandans who are qualified, including some among you who may be considering career moves.
Thank you, thank you. Honorable members, I put a question that clause 2 be amended as proposed by the Honorable Minister of Constitutional Affairs and amended by and considered by the chairperson of the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the committee. Those in favor say on the contrary, nay. The ayes have it.
Title.
I put a question that the title stands part of the committee. Those in favor say on the contrary, nay. I put a question that the title stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Motion for resumption of the House.
Honorable Minister.
Honorable Chairperson and honorable members, I move that the House resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say on the contrary, nay. The ayes have it.
This is a cow. It has a tail.
Report of the Committee of the Whole House.
Honorable Minister.
Madam Speaker and honorable members, the Committee of the Whole House has considered the bill entitled the Judicature Amendment Bill 2023 and passed it with amendments. Motion for adoption of the report of the Committee of the Whole House.
Honorable Minister.
Madam Speaker and honorable members, I move that the report from the Committee of the Whole House be adopted. I beg to move.
I put a question that the House adopts the report of the Committee of the Whole House. Those in favor sign the contrary nay. The ayes have it.
Bill's third reading, the Judicature Amendment Bill 2023.
Honorable Minister.
Right, Honorable Speaker and honorable members, I move that the bill entitled the Judicature Amendment Bill 2023 be read a third time and do pass. I beg to move.
Thank you, Honorable Minister. The quorum we have virtually 62 and fiscal 181. So we have the quorum. I put a question that the Judicature Amendment Bill 2023 be read a third time and do pass. Those in favor say on the contrary nay. The ayes have it.
A bill for an act titled the Judicature Amendment Act 2023.
Bill passed and settled. Thank you. Next item.
Item 6, statement by Minister on alleged enforced disappearances of persons.
Honorable members, as I guided yesterday, today we will receive a response by the executive to the concerns raised by the leader of opposition in Parliament regarding the enforcement of disappearances of persons and other human rights related matters. This is in fulfillment of the directive of the presiding officer then on 19th October 2023. The minister was supposed to bring a statement on 19th, which fell on a weekend. They were now supposed to come back on 21st, and they wrote to my office asking for an extension for 1 week. And today, the minister has informed us that he's ready. And because the minister has given us the document, which has been duly uploaded, can we now listen, attentively listen to the minister? Honorable Minister.
Right, Honorable Speaker and honorable members. This is a response to the issues raised by the leader of the opposition in Parliament regarding his statement about alleged human rights abuses and shrinking of civic space. This follows a directive by the Speaker to make a response. Introduction. This statement constitutes the response to the issues raised in the statement by the leader of the opposition in Parliament titled Human Rights Abuses and Shrinking of Civic Space. It is attached as Annex A herewith. This statement contained the following. 1. That Uganda is among the worst human rights abusers in the world. It also included fresh resubmission of matters regarding the November 2020 riots and attendant deaths and other issues, namely that the report about those events was never published. 2, that a reported police vehicle cited as 99917 and its alleged involvement in indiscriminate shooting of people during the riots. 3, a military police vehicle registration number H4DF 2382 and its alleged deliberate cause of death to Saint as a Frank. 4, police vehicle registration number UP4841 and its alleged advertent cause of death to Rita Nabukera. 5, submission of 21 names of people reportedly killed during the riots in November 2020. 6, submission of the names of 18 persons reportedly missing and resubmission of the same list of reported missing persons with next of kin stroke contacts through the Speaker of Parliament, vide letter of 19th October 2023. The statement also raised alleged victimization of Muslims and claimed that there are more Muslims in detention or custodial centers than any other denomination. It also contained an allegation about widespread detention without trial and claimed that over 500 NUP supporters arrested in 2020-2021 were detained without trial and released after payment of a ransom from both military and civil custody, and that 50 still remain incarcerated at Kitalia government prison. And last, alleged human rights violations in fishing communities, including claims of rape, defilement, property destruction, murders, unjustified arrests, and illegal closure of landing sites. Right Honorable Speaker and members, allow me to respond to each of these as follows. The statement that Uganda is among the worst human rights abusers in the world is sweeping and unsubstantiated and false. It is and remains government's enduring policy and conviction to respect and protect human rights. In the unlikely event that infraction by individual agents of government, whether in the course of their employment or outside the scope of their employment, or even where private citizens are involved in alleged abuses, the matter can only be addressed in specific terms and not in a casual and generalized way. Relatedly, I want to comment from the onset and to debunk the misrepresentation in the title of the statement by the Honorable Lop about the generalized claim of gross abuse of human rights and so-called shrinking civic space. Right Honorable Speaker and honorable members, democracies evolve worldwide. Uganda is one of them. We've made tremendous, remarkable strides from the individual merit of the movement system of yesteryears, which was all-inclusive, to the multi-party dispensation that obtains today. The decision to introduce the current political dispensation was conscious and deliberate, to allow those who felt uncomfortable under the movement broad-based system to seek the ideological shelter of their comfort for political expression. While the movement system was non-exclusive and served well in the interim to foster national unity post-liberation, the multi-party system allows for people to politically organize distinctively and exclusively around their party ideology. This expanded civic space, created by that bold measure of government, has enabled the obtaining diversity in the character of our national politics, including the composition of parliament, which is comprised variously by members of the NRM, different political parties, independents, special interest groups, to mention but a few. Quite often, you may hear voices castigating this diversity, this variety, with all its peculiar characteristics. However, such are the compromises of democracy, especially nascent democracies, to afford equal space to everyone to participate in the politics of the country. Some costs notwithstanding. Possibilities and opportunities have therefore been opened for everyone, thanks to the government's big tent approach. In some, the space that allows for the emergence of such diverse participation and expression can be anything but shrinking. Issues to do with the November 2020 riots and attendant loss of lives, injuries, destruction, and related matters. Right Honorable Speaker and honorable members, this is yet one other additional response on this matter and all others incidental thereto. Contrary to what the Honorable Lope claims, an investigation was done immediately after the riots, and a report to that effect was presented to the last parliament by the then Minister of Internal Affairs. That, in addition to other subsequent numerous responses made about the subject matter, including in this parliament. I needed to make that clarification from the onset to clear the air. That said, and by way of a recap, violent riots broke out and rocked various parts of the country in November 2020 before they were quelled by police and other security agencies. These riots covered Kampala and Wakiso, which were the epicenter of the riots, as well as Mukono, Masaka, Chotera, Rengo, Mpiji, Luero, Oblenzi, Mitiana, Lugazi, Njeru, Jinja, Buenge, Iganga, Namayingo, Namtumba, Luka, Kamuli, Budaka, Busia, Mbale, Arua, and Gulu, respectively. During these riots, extensive loss of property, private and public, and damage to and loss of lives were registered. The destruction incidental to the riots or directly arising from the various riotous acts was immense. This included deliberate acts of arson or torching of buildings and vehicles, use of stones and other objects to hit innocent members of the public, motorists, security personnel and property, physical assault, manhandling and abuse of members of the public as well as law enforcement officers, staging of illegal roadblocks and demanding money with menaces from members of the public. There was also burning of tires to damage and block public roads and throwing petrol bombs into buildings and at security/law enforcement officers, among others. During this chaos, even ordinarily sanctified places like court premises were not spared. Woolens court premises were set ablaze. 56 people lost their lives, including those by gunshot wounds and others whose death were through other causes incidental to the riots. The latter category includes those that lost their lives as a result of accidents, motor vehicle accidents involving, for example, vehicle registration number UAN H27N, whose driver lost control after being hit by a stone and knocked 2 people dead, namely Nalwada Kevin and Nsimbe Shafiq. 46 people out of the 56 victims were male adults and 3 were male juveniles. 48 of the victims were from Kampala metropolitan areas also. This includes Kampala, Wakiso, and Mukono. 2 were from Jinja, 2 were from Luero, 1 from Rakai, 1 from Chinoni in Lwengo, 1 from Butambala, and 1 from Mpiji, respectively. Right Honorable Speaker, honorable members, security operations are governed by the law to ensure and guide the participating forces on the employment of lethal force. This is ensured through a number of ways, including training, briefing before operations, and debriefing post-operations, as well as dissemination of rules of engagement, which have been distilled and reduced into pocketbooks for the tactical operators. The SOPs on the use of force booklet is attached as Annex B to this statement. These are the aid memoirs to assist operators to make informed and rational judgment, depending on the circumstances of each case and the prevailing situation, but mindful of the principles of necessity and proportionality in the use of force. These measures, Right Honorable Speaker and members, were in place. The investigations done post the riots established the cause of death and injury without conclusive findings about the circumstances of which of the death and injuries, save for LDU auxiliary number 01700, Mustafa Sali, who was charged and convicted for the killing of Mutasa Ibrahim on 18th November 2020 at Wandegea Police Station, and RA 172962 Lance Corporal Mjisha Augustine, charged and convicted for the killing of civilian Grace Walungama and fellow LDU Senoga Hussein at Lunguja on 18th November 2020. These two were each sentenced to 35 years and life imprisonment respectively, and are serving their sentences at Kitalia Prison. The other specific attribution of cause of death is in respect of two deceased persons, namely Nalwada Kevin and Simbe Shafiq, I referred to them earlier, who were knocked down by the vehicle registration number UAN 827 and Toyota Alex when the driver lost control after being stoned by rioters. There's an attached annex to Right Honorable Speaker and members, which shows the number of people who are arrested and arraigned in the courts of law in the number of 1,088, 949 of whom were charged and 333 convicted for various offenses related to the riots. 14 of these, the total number of the people arrested, were charged for terrorism and aggravated robbery and remanded. 128 were discharged, 474 were released on bail, 60 were bonded, 79 were cleared by the police. Annex J contains the details of these statistics. Right Honorable members, government keeps open the window for any fresh and incontrovertible evidence pointing to individual culpa regarding alleged wanton and unjustifiable use of excessive force in order to ensure that the ends of justice and accountability are served. The list of the deceased persons is also here with attached as Annexure C. Vehicles mentioned in Lop's statement. Investigations are not conclusive regarding the alleged involvement of the crew of a vehicle mentioned as UP 999 and marked number 17 on its door in the November 2020 riots. The BBC documentary dubbed Free Killings has been established to be the source of this allegation. The registration number of the said motor vehicle is not shown and is under verification. Where the clip was taken, when and by whom, are not easily ascertainable to enable the requisite verification of the contents of the said clip. The investigations done post the riots, the allegation that military vehicle registration number H4DF 2382 was advertently responsible for the death of Senteza Frank is also not true. Investigations conducted, reference Natete TAR 90/2020, revealed that the said Senteza Frank fell off a speeding vehicle number UBH 856T minibus Toyota Hiace used by the NUP supporters during the incident at Busega roundabout, where the deceased, who was reportedly part of the inner detail of the NUP leader Robert Chagulanyi Sentamu, had with others aboard the mentioned minibus vehicle jumped out and encircled their principal's vehicle, which had slowed down for him to wave to the roadside crowds when the principal's vehicle sped off, all the others except the deceased managed to reboard the moving Toyota Hiace minibus in time. The deceased was not as fortunate and fatally fell off after missing a step in his unsuccessful attempt to reboard the said minibus vehicle. The military police vehicle mentioned was following this motorcade from behind when the incident happened, but is not responsible for this fatality. There was media footage that time regarding this incident, which vindicates this narrative. The deceased was rushed to Rubaga Hospital, where he was pronounced dead on arrival. He was hurriedly buried with no post-mortem conducted. The crew of the military vehicle are available, so too are other ordinary people who witnessed the incident and have all given their credible testimony about the matter. A coroner's probe into the death, had it been allowed to be done, would have rested this matter. Needless to mention that the conduct of the occupants of the above-mentioned minibus of jumping on and off a moving vehicle, which resulted in this fatality, was without a doubt in total disregard of caution and in breach of the traffic and road safety laws of the country. The allegation that a police vehicle registration number UP 4841 was involved in the deliberate killing of Rita Nabukera and the matter remained uninvestigated is also not true. The driver of that vehicle, constable number 39975 Atikuru Nasasra, was arrested and the matter subjected to investigations. Following the conclusion of these investigations, the file was forwarded to the RSA, Nakawa, for sanctioning of the charge against its suspect in the course of law. The regional state attorney, however, didn't sanction the charges, reportedly because the evidence on record was not sufficient to support the charge of causing death through reckless driving, contrary to Section 1081 of the Traffic and Road Safety Act. All this is available for cross-checking. Injuries. A number of people are injured in the riots, and their names are listed in Annex D to the report. These include the widely publicized case of the police female officer whose violent attack by rioters with a hammer was captured on social media. This is ASP Kasule Consolata. Compensation. The government has undertaken to compensate the victims of the riots, deaths and riots who opt to settle out of court, while those who sued government have their cases ongoing and will be handled according to the outcome of the cases. The Office of the AG is handling the matter. Missing persons. Right Honorable Speaker, honorable members, the safety and security of persons residing within the territory of Uganda is the responsibility of the government. Disappearance of persons, whether the hands of the state or even by private persons, could inevitably be of concern to government. The Constitution of the Republic of Uganda guarantees the protection of personal liberty and also provides permissible lawful circumstances under which the right to liberty can be interfered with. The manner of arrest, including by members of the public, is well provided for in the law. Once lawfully arrested, a suspect should be held in a legally gazetted place. In addition, our criminal justice system is premised on the presumption of innocence. During arrest or once arrested, only reasonable, proportionate, justifiable, and lawful application of force is permitted to cause the arrest of a suspect or to restrain him or her in the event that the suspect acts in a manner incompatible with lawful confinement. No one, except a court of competent jurisdiction, through a fair trial process, can determine the guilt of a person and the accompanying penalty. This renders actionable anything outside the law regarding the conduct of arrests and management of suspects in custody. This is the law. It has also been reinforced by various SOPs, including guidance from the Commander-in-Chief himself, attached herewith as Annex E. That said, Right Honorable Speaker, honorable members, the Uganda Police Force did conduct investigations into the matter of the alleged missing persons. The police, however, was confronted with a number of challenges and constraints which do compromise the integrity of the findings from the people given by the Honorable Lop as next of kin. The next of kin of the reported missing persons, first of all, didn't cooperate with the police investigators until the police team had to hold out as members of an NGO in order to interview these people. For example, Navakoza Florence, the next of kin of Wangolo Dennis, alias Shafik, declined to meet the investigators, stating that she had not got instructions from Loop to meet any person. Nanyonjo Oliver, the reported next of kin to Luemba Mustafa, made further reference to one Musisi, who became hostile when the team requested to meet him. Later, there emerged trending videos and audios from the Honorable leader of opposition that the police team wanted to meet this next of kin at night, which wasn't true. The next of kin preferred dealing with NGOs as opposed to the official investigative agency of government, the police, which makes the work to find the truth about the matter extremely difficult. People who are allegedly arrested with some of the reported missing persons also refused to make statements. For example, Musa Sali, Kasasa Amim Muwaire, and Sembajwe Hakim, who allegedly arrested with Semudum Michael Jackson, declined to provide information to the police. Most of the alleged disappearances were never reported to the police. For example, the alleged disappearance of Damlira John, Chiria Peter, Wangolo Dennis, Cesaz Isma, Mubiru Hassan, Bagumba Joseph, alias Semuju Joseph, and Zimura Dennis, alias Boy, were all never reported to the police. Right Honorable Speaker and members, it is the law and official practice that for one to be declared a missing person's report must be filed. This can only be with the police, which wasn't done and which is still being resisted by the people approached. Hearsay testimony by the next of kin and witnesses. Most of the next of kin aren't eyewitnesses to the alleged disappearances. They were recounting to the investigators, CAM NGO, the stories of the arrests as told by unidentified and unascertainable third parties and third sources, which renders these secondary testimonies unreliable and less corroborated. Fictitious people. Investigations reveal that there exists no Semuju Joseph as listed in LOP's tabulated matrix serial number 10. The contacted next of kin insisted that the alleged Semuju Joseph is actually Baguma Joseph, serial number 17. Whose alleged disappearance was never reported. Searches were carried out in different government data banks, to wit Interpol, Forensics, NIRA, City Mortuary, Kampala, and Immigration. The NIRA records information of 9 people out of the 18 wasn't available. The data profile lack thereof from the various agencies for the given names is contained in Annex F, and I will refer to each of the names later. Some cases where the leader of opposition attributed an alleged disappearance to security had been reported earlier by the relatives of these people as unwitnessed disappearances. And these include Kasumba George, Kisembo Godfrey, and Kibalama John Bosco. Despite most of the alleged occurrences being reported to have taken in broad daylight, none of the alleged witnesses mentioned the registration number plates of the alleged vehicles involved. It has also been established that there's a well-orchestrated smear campaign of aiding people who seek to go abroad in search of livelihood opportunities to claim political persecution and/or persecution for belonging to sexual minorities. These false and mendacious claims against government are unfortunately sometimes believed by those in the host countries who are gullible to take these claims as true without verification. Others still sometimes are fugitives from justice. For example, the suspects who had evaded appearing in court for assaulting a one Kamuntu Ivan, alias Majambere, were aided to leave the country. These are Onzima Godfrey, alias Tower, and Shikomeko, alias Yekolera, alias Itongwa, who assaulted Majambere and were due for prosecution when they fled. Onzima eventually returned and was charged but granted bail. Inconsistencies in the numbers and testimonies in the various claims of reported disappeared persons presented variously to the Human Rights Commission, the Parliamentary Committee on Human Rights, and the latest statement by the opposition, respectively. The respective reports are hereby attached as Annex G1, G2, G3, respectively, for references regarding the inconsistencies. In a nutshell, lack of cooperation and the refusal to report, coupled with the other concerns raised in this response, make it extremely difficult to come to the bottom of the matter of alleged disappeared persons. Right Honorable Speaker, alleged victimization of Muslims and claim that there are more Muslims in detention than the other denominations. Uganda is a secular country. The right to freedom of worship is guaranteed by the Constitution of the Republic of Uganda. The government is and has always been committed to respecting the rights of all people, irrespective of their faith. Participation in crime in all its manifestations is an individual choice. Any attempt, therefore, to seek shelter in ethnicity, religion, gender, or political affiliation in order to evade criminal liability is grossly misleading and untenable. In the unlikely event that there are wrongs committed by law enforcement or security agencies in the course of their work, including the conduct of arrests, these should be addressed according to the specific circumstances of each particular case, but not on the basis of the identity of the suspect. It would be wrong and unlawful for law enforcement to mistreat a Muslim by applying methods that are in contravention of the law, as it would any other person of a different faith, or even those that don't subscribe to any religion at all, for that matter, because the sanctity of human life and attendant rights are common to all, irrespective of identity or social standing, and should be respected and protected as such. The statistics from the Uganda Prison Service as of 30th September 2023 indicates that Muslims constitute only 16.4% of the inmates of all Uganda, in all Uganda's prisons. They fall far behind Catholics, who are 43.1%, and Protestants, who are 29.5% respectively. It is therefore clearly not true that the number of Muslims in prisons is bigger than that of the other denominations, even in relative terms, in terms of population ratio. It is also equally not true, because of these statistics, that the Catholics and Protestants are targeted on account of their faith. The detailed statistics from the Uganda Prison Service are attached as Annex H1, H2, H3, and H4 for reference. Pre-trial detention. The government strives to ensure that only persons charged before competent courts of law are held in prisons, and every suspect has its commitment warrant. Indeed, government is duty-bound to ensure that the persons in custody are lawfully arrested, duly charged, and lawfully remanded in prison. The fate, therefore, after all this due process, lies with the courts of law once they are charged. However, it may be the case sometimes, due to the nature of investigations of some cases, for suspects to be held beyond 48 hours before they are charged. Government is working around the clock. The government is working around the clock to ensure that these issues are sorted and due process is followed, including the possibility of legal reforms as well as other pragmatic administrative measures to improve our criminal justice system. And I'm glad as I came here, one such measure was being handled by Parliament. Government acknowledges that in the recent past, the judicial system was bedeviled with pretrial detention, also partly owing to the limited number of judicial officers and prosecutors. Government has addressed and continues to address this matter through the recruitment of more judicial officers, prosecutor, and state attorneys, and the increase of high court circuits, Court of Appeal circuits, and the magistrates' courts. Indeed, the independence of the judiciary has also been enhanced by the enactment of the Administration of the Judiciary Act 2020. It is expected that these interventions will bolster the efficient disposal of cases and thereby drastically address the issue of pretrial detention. In any case, there are also remedies other than suing government, which anyone can invoke within the law presently for those cases of detention beyond the prescribed period before trial. These include the right to invoke the writ of habeas corpus, among others. Alleged human rights violations in fishing communities. Prior to government's strategic decision to deploy UPDF on the waters of Uganda, the fishing industry was on the brink of collapse, and fish processing industries had begun to close. This was attributed to the indiscriminate and unregulated fishing by the fishing community. There has been tremendous improvement in the fishing industry, thanks to this intervention by the president of setting up the UPDF task force to deal with irregular fishing. In the course of its work, however, complaints of misconduct by personnel of this unit have sometimes been registered. The UPDF has a code of conduct which since its inception as NRA has been integral to the law governing the UPDF. That is the UPDF Act and the NRA statute before it. The UPDF arose out of popular frustration against misrule, including repressive behavior against the population by members of the armed forces. No wonder in the Constitution of Uganda, the befitting name of choice for the force was UPDF, emphasizing the founding character of the UPDF as a people's force. I want to assure the House that this remains the case, and whoever deviates within the ranks is dealt with according to the law. What I know and is public, illegal fishing gear, as well as the immature fish, once impounded, are usually publicly disposed of. I wish therefore to report that many of these complaints have been dealt with and the culprits punished. The details of the information about the cases registered and action taken is available with the MOD, Minister of Defense and Veteran Affairs. Alleged political prisoners in custody. Uganda is a democratic country under the multi-party dispensation. The rights to freedom of association and expression are guaranteed under the 1995 Constitution of the Republic of Uganda. It's not a crime to belong to a political party and to lawfully carry out and participate in the activities of political parties. Premised on the above, the government of Uganda doesn't arrest people because of their political inclination. People are arrested and charged for suspicion of commission of crimes that are clearly prescribed under the law. The people reportedly held in custody were charged with various offenses, and the courts will determine their cases. If there are complaints about the conduct of these cases, there are remedies within the law which can be invoked by the complainants. Agencies and institutions of government are not above the law. The General Court Martial's jurisdiction, which is being challenged in Lop's statement, is a lawful court and has jurisdiction over the trial of civilians, where such civilians are charged with offenses of the nature that brings them under the ambit of the jurisdiction of this court. This is the position of the law until the matter of the court's jurisdiction is settled by the Supreme Court, where an appeal about the court's jurisdiction presently lies. The details of the persons under trial at the GCM are in Annex I for reference. In conclusion, Right Honorable Speaker and members, the government of Uganda is committed to the respect, observance, promotion, and protection of human rights of all its citizens. It's one of its core values and beliefs. Government has its roots in resistance against misrule, characterized by gross violations of human rights. Therefore, wrongs within its ranks, in the unlikely event that they happen, cannot be systemic. They can only be individual mistakes, which should certainly also be dealt with. It's government's consistent commitment to expose and punish mischief within its ranks, even when sometimes it may take time to do so for a number of unintended reasons and circumstances. Government believes in accountability, believes in the rule of law and compliance with due process. Incidentally, there is no limitation period in our laws as far as criminal liability is concerned. Any fresh and credible information is welcome, provided it is reported officially to the appropriate authorities in order to aid the conduct of formal investigations. The response, Right Honorable Speaker and members, suffices to illustrate that compliance with due process is not mere sloganeering of formality. It is government's founding and enduring philosophy. Last, I would want to remind our colleagues in the opposition that democracy is not just about the exercise of right. It's also about observance of the duties and obligations that accompany those rights. It's about the exercise of civility and leadership, even in instances where we may have divergent perspectives on how to build, grow, and consolidate our democracy. Towards this end, government has always been willing to constructively engage on these and other pertinent matters. Hopefully, our colleagues are also willing to reciprocate and stand tall above prejudice and politicking to use the available abundant civic space for the advancement of our common good. Right Honorable Speaker and Honorable Members, this is our considered response. I beg to submit, Right Honorable Speaker and Honorable.
Thank you. Thank you so much, Honorable Minister. Honorable members, in the public gallery this afternoon, we have a delegation of student leaders. Keep quiet. Okay, Rod, I will throw you out. In the public gallery this afternoon, we have a delegation of student leaders from Uganda National Students Association, that is Blambul. You're most welcome. They are represented by Honorable Nangoli Gerald and Honorable Nafuna Muloni Irene Margaret. Most welcome, and thank you for sending us very good members of parliament. Thank you. Please join me in welcoming them. Honorable members, I have an invitation from the chairperson of the Parliamentary Prayer Breakfast Fellowship. The invitation is for tomorrow from 7:30 to 9:30, and Apostle Grace Lubega will be the one ministering in the conference center. So kindly come for the prayer breakfast, end of year prayer breakfast. We've had a report from the Honorable Minister, and it is a very long report. When you look at the annexes, you've seen all these annexes. Honorable Lop.
Much obliged, right, Honorable
Honorable
Speaker.
members, just a polite warning. I don't want to hear noise on either side. Listen to the person speaking.
Right, Honorable Speaker, I would like to appreciate the Honorable Minister of State for Internal Affairs for reading out a statement signed off by his senior who never attends to House plenary since he was vetted in a committee in which I was a part. Right, Honorable Speaker, Leon Tolstoy was a philosopher, political philosopher from the 19th century, and had this to say: if you feel pain, you are alive. If you feel other people's pain, you are a human being. Let each of us place ourselves in any of those spaces, whether we are both or one of those. Right, Honorable Speaker. Right, Honorable Speaker, the power of the people is resident in this House of Parliament, and the power to sustain it is domiciled in Parliament. And therefore, nobody can repurpose the power of Parliament to sustain, maintain, and assure the power of the people. I graciously received this document around 11 o'clock from the minister, and I appreciate. It's a 17-page document authored over a period of 40 days. If you divide 40 by 17, it can speak to the number of paragraphs authored on each day. We appreciate the attempt to respond to this. Right, Honorable Speaker, it should never take anybody with any power 40 days to respond to the needs of the people, especially when it relates to rights, Right, Honorable Speaker. And it's 40 days plus 2.5 years, Right, Honorable Speaker. Right, Honorable Speaker, now that we have received this, I would like to ask of your indulgence to allow me and my team to make a rejoinder to this statement. And this rejoinder will place each one of us in the philosophy of Leon, whether we are actually alive or indeed we are humans. Honorable Speaker, I don't need 40 days. I'll be back on Tuesday to make a rejoinder, Honorable Speaker. And in that rejoinder, I'll make very particularized prayers for which this House of Parliament will be on taste. I'm glad I'm here, Honorable Speaker, that I have learned new phrases and new words such as unwitnessed disappearance. When the Honorable was mentoring,
can we first handle on your prayer?
Honorable Speaker, I so pray that the prayer is finds your consideration, that we make a rejoinder so that we can make good sense out of this 17-page document authored across 40 days. I give it to pray.
Thank you. That is the civil Honorable Mpuga I know. Honorable members, the report came a little late and we expect a rejoinder from the opposition. And it's just prudent enough that we give the leader of opposition to bring his rejoinder on Tuesday at 2. And then we'll have this report. We'll take a decision on that day on what we'll do. I now adjourn the House to 2 tomorrow.